Drowning in refund requests, conformity disputes, or 2-year warranty claims that look more like extortion than fair play? If you sell goods or digital content into the EU, your compliance setup is either quietly bleeding you cash or quietly shielding you from it. There's no middle ground. Today, we'll show you exactly where the EU framework will bite your business and how to make sure it doesn't. First, a quick disclaimer. This video is for informational purposes only and does not constitute legal advice. If you'd like tailored review of your terms, your conformity policy, or your refund flow, our team is just one click away. Hey everyone, Robert here, legal consultant, licensed tax advisor, and founder of Chiroptera Consulting. We work day in, day out with e-commerce sellers, dropshippers, Amazon merchants, SaaS founders, and streaming platforms operating into the EU. And we've seen the exact same compliance gaps cost businesses serious money again and again. So today we're flipping the consumer rights story around and looking at it from your side of the table. What the EU actually requires of you and how to use the rules to your advantage. 3 EU directives shape your refund and warranty exposure, and a 4th is about to reshape it again. The Consumer Rights Directive 2011/83, as amended by the Modernization Directive 2019/2161, sets your pre-contract information duties and the famous 14-day right of withdrawal for distance and off-premises sales. The Sale of Goods Directive 2019/771, enforced since the 1st of January 2022, governs your liability for tangible goods, including so-called goods with digital elements, like smart TVs and connected appliances. And the Digital Content Directive 2019/770 governs your liability for digital content and digital services, like apps, games, streaming, SaaS, and ebooks, including those free services where users pay you with their personal data. Here's the headline number you need to memorize. Under Article 10, Paragraph 1 of the Sales of Goods Directive, you are on the hook for any lack of conformity that exists at the time of delivery and becomes apparent within at least 2 years from delivery. 2 years is the EU minimum. Many member states have longer periods, and if you sell cross-border, you inherit the longer one when local law applies. And from the 31st of July 2026, the Right to Repair Directive 2024/1799 extends that liability period by a further 12 months whenever the consumer chooses repair. So, if you haven't started reorganizing your warranty reserves and your supplier indemnities for that, now is the time. For digital content, Article 11 of the Digital Content Directive sets the same 2-year minimum for one-off supplies, but for continuous supply like a streaming or SaaS subscription, you remain liable throughout the entire contract period. That's a structural difference that catches a lot of subscription businesses off guard. And one more piece of bad news up front. Liability is objective. The consumer doesn't have to prove your fault, only non-conformity. Even worse, under Article 11 of the Sales of Goods Directive and Article 12 of the Digital Content Directive, any defect appearing within the first year or 2 in the member states that extended it is presumed to have existed at the time of delivery. The burden of disproving that presumption sits squarely on you. So how do you actually defend yourself against meritless claims? Documentation, and again, documentation. The conformity presumption is rebuttable, but only if you can show with time-stamped evidence that the goods or service were in conformity at the moment of supply. That means quality assurance, records, batch testing logs, version-controlled software builds, server-side logs of digital service delivery, and update notification timestamps. If you haven't built that evidentiary trail, you'll lose the close calls. Build it once and you'll win them. For digital content specifically, Article 8, Paragraph 3 of the Digital Content Directive gives you a powerful exemption that most businesses fail to invoke properly. If a defect arises solely because the consumer didn't install an update, you are not liable for that non-conformity, but only if you informed the consumer of the availability and consequences of the update, and your installation instructions weren't defective. Most businesses don't capture that proof. Their support team waves the defense away by accident, and the company gets a refund it never legally owed. Log down your update notification workflow on a durable medium, and that single fix typically pays for our entire compliance retainer in a quarter. Now to the part most sellers misunderstand and that genuinely costs them money. The Sales of Goods Directive and the Digital Content Directive both establish a strict hierarchy of remedies. Consumers do not get to pick refund off the menu. They have to climb the ladder. The primary remedies come first: repair or replacement for goods, under Article 13 of the Sales of Goods Directive, bringing the digital content into conformity under Article 14 of the Digital Content Directive. And here's the leverage you have. Under Article 13, Paragraph 2 of the Sales of Goods Directive, you may refuse the consumer's chosen remedy if it is impossible or disproportionate compared to the alternative. Assessed against the value of conforming goods, the significance of the defect, and whether the alternative would cause significant inconvenience. That's not a courtesy clause. It's a real structured pushback that competent sellers use all the time. A torn jacket gets repaired, not replaced. A buggy app gets patched, not refunded. The secondary remedies, proportionate price reduction or termination, only become available where you failed or refused the primary remedy, where the defect reappears, where it's serious enough to justify immediate termination, or where you've signaled you won't perform within reasonable time. And critically, under Article 13, Paragraph 5 of the Sales of Goods Directive and Article 14, Paragraph 6 of Digital Content Directive, the consumer cannot terminate for minor defects. The burden of proving the defect is minor sits on you. But if you can carry it, you keep the customer and the contract value. The exception worth knowing is for digital content paid only with personal data. There, even minor non-conformity allows termination, since price reduction isn't available. Now to the traps. These are the 5 compliance gaps where we routinely see clients hand consumers refunds they were never entitled to. The first is the withdrawal information failure. Under Article 10 of the Consumer Rights Directive, if you don't properly inform the consumer of the 14-day withdrawal right before the contract is concluded, that period is automatically extended by 12 months. We've seen merchants on the wrong side of that extension lose mid-5-figure sums to refund requests they could have closed on day 15. Your withdrawal notice has to be in your pre-contract information, in plain language with the model withdrawal form attached, and ideally confirmed on a durable medium. The second, for digital businesses, is the missing acknowledgment under Article 16, Paragraph 1.m of the Consumer Rights Directive. To start performance during the withdrawal window without giving the user a free trial, then refund loophole, you need 3 things. Prior express consent to begin performance, an acknowledgement that the consumer thereby loses the right of withdrawal, and confirmation on a durable medium. Miss any one of them, and under Article 14, paragraph 4.b, the consumer pays nothing for what they've already used. Build it into your checkout flow, not your terms and conditions. The third trap is over-disclosure in pre-contract information. Under Article 6, paragraph 5 of the Consumer Rights Directive, the information you provide before the contract becomes binding contractual content. So if your sales page promises lifetime updates or compatibility with all major browsers, you've just contracted into a conformity standard you may not be able to meet. Tighten your marketing copy, have legal experts review the sales page, not just the terms. The fourth is missing the Article 14 paragraph 3 installation framing. Under that provision, when goods need to be removed and reinstalled, you bear the cost, but only where the goods had been installed in a manner consistent with their nature and purpose. If your terms or installation guidance can document that the consumer's installation was inconsistent with that standard, you have a defensible position. Without that documentation, you don't. And the fifth, the one we see most often in cross-border e-commerce, is failing to invoke your right of redress upstream. Under Article 18 of the Sales of Goods Directive, where you're held liable to the consumer because of an act or omission by someone earlier in your supply chain, you keep your rights against that party, but you only collect if your supplier contracts are drafted to capture the indemnity. Most aren't, but we can fix that. One landmark case worth knowing: the Joint Court of Justice cases C65/09 and C87/09, decided on the 16th of June 2011, are usually cited as a consumer protection win. And they are, but for sellers they also contain a critical financial cap. The court ruled that where the seller has to replace goods the consumer installed in good faith, the seller bears the cost of removing the non-conforming goods and installing the replacement. So far, so painful. But the court also ruled that national courts may limit the seller's reimbursement to an amount proportionate to the value of conforming goods and the significance of the defect. That cap is now reflected in the Sales of Goods Directive. If your replacement obligation is being weaponized against you, that cap is your relief, and a properly framed legal response invokes it from the first letter. So, what does a defensible setup actually look like? It looks like this. Pre-contract disclosures tight enough to comply but disciplined enough not to overpromise. A withdrawal flow with proper consent, acknowledgement, and durable medium confirmation. A Q&A and version control regime that produces evidence to rebut the one-year presumption. An update notification workflow that captures Article 8, Paragraph 3 protection. Standard refund claim playbook that escalate the hierarchy of remedies in writing. Repair offered first, replacement second, price reduction or termination only where the law actually requires it. Supplier contracts with proper redress and indemnity clauses, so when you pay, your supplier pays too. And a clean separation between your contract terms, your privacy policy under the GDPR, and any AI-related obligations under the EU AI Act and the revised Product Liability Directive 2024/2853. Get this architecture right and your refund rate drops, your dispute resolution times shorten, and your warranty reserves stop bleeding into your margin. Quick recap for sellers. You face at least 2 years of strict liability on goods and longer in many member states. 12 months more if the consumer chooses repair once 2024/1719 applies. Liability is objective and presumed in the consumer's favor for the first year, so documentation is your evidence base. Use the hierarchy of remedies as your shield. Repair before replacement, replacement before price reduction, and never termination for a minor defect. Lock down your withdrawal information and acknowledgement flow before it triggers a 12-month extension. And capture redress against your supply chain, because Article 18 only helps the merchants who drafted for it. The EU framework looks like a wall of consumer rights. It's actually a structured set of obligations that, if you set them up right, protect your business as much as they protect the consumer. The merchants we see thrive in this market are the ones who treat compliance as competitive infrastructure, not as cost. If you're not 100% sure your withdrawal flow, your conformity policy, or your supplier contracts would survive a serious dispute, that's exactly what we do. Book a free 30-minute, no strings attached consultation through the link in the description below. We'll walk through your specific risk points. Hit like, share this with your colleagues, and subscribe for more compliance insights for digital and cross-border businesses. Thanks for watching, and remember, compliance with the law prevents the flaw. Till next time.